Good evening, viewers. This is Attorney Naresh Gehi. A wonderful topic today, downgrading from your EB2 application to your EB3 application, especially if you're from India. Such a fantastic topic. Too many people asking me questions. Too many companies trying to reach me to check whether they should actually downgrade their employees into this particular category or no. So it's very important for us to go through everything in intricate detail so that we can actually talk about it with our viewers as to what steps they need to take and how they need to basically, handle such situations. So the most important thing here for all of us is to ensure that whether it's really worth it for you to actually downgrade from EB2 to an EB3 category. So the October bulletin is going to be the most important thing for you to look into. Now, this is going to help people wherein the priority dates are between 2011 and 2015. That's the first thing you need to know. Secondly, if you are downgrading, is it worth the aggravation? That's the second thing you need to know. Thirdly, you need to see how close you are from your category becoming current, if you're especially in the EB2 category. So those are some of the factors I would look into very carefully. Now, in terms of people, because everybody who's in that particular group from 2011 to 2015 under the EB2 category seems to be in a mad rush of getting the paperwork done. And especially even people who are after that cutoff date seem to be in a big rush whether I need to proceed with this or what I need to do, what I should not be doing. So what is very important for all of us is to understand what is really required. So the easy way to explain it is by means of question and answers to our viewers. It's going to be really easy when I'm going to make it real simple for you. Take an example. You are a consulting company and you have this employee working for you. And you file for him under the EB2 category. And at this stage, your employee is from India. He came to you and he spoke to you. He said, "Sir, can you please help me to downgrade this category?" So the very first thing is that you need to make sure whether it's really worth it or no. Now, there are people who have been on H-1Bs for a very long time. And they actually are kind of very desperate that they want to do this. But remember one thing. Now, by the time you're going to downgrade from an EB2 to an EB3, there are many other people who are doing the same thing. You should do it for those employees whom you really care as an employer that are really kind of in need of the situation. Now, I would look into a couple of factors if I was an IT company owner or was the owner of a company. His wife or her husband is not working. That's number one. Secondly, while I'm downgrading, at this point of time, is his priority date really current? Because a company also has to look into those issues. And if the category is current, at that time, whether is this an employee that would stay with me? That is very important. Now, that's why we represent a lot of companies over here. Because what is happening in the market is that you have this employee, he wants everything his way, but you need to also look at everything objectively, whether you are in full compliance of the law or whether your company can be audited because you're doing it for every Tom, Dick, and Harry. So these are factors that companies should consider while they're downgrading. And secondly, what is going to happen? Your company did it. You did it for him. And right now, this employee is very happy. He's jumping in joy because his I-140 is approved. His I-485 has come into the picture. And now, after 6 months, he's using AC-21 and leaving you. So is that something that your company is ready with? That is a factor for you to look at. That's number one. Secondly, if you're doing it for that employee, well and great and dandy. The other issue is that there are going to be hundreds of people who are going to apply for this. Now, what is going to happen? There's a very good saying, history repeats itself. So what may happen in this case is the EB2 dates will start coming up sooner, and EB3 can be backlogged. Now, if you are an employee, why should you do it? Now, I'm going to talk from both the perspectives, from an employer's perspective. Now, from an employee's perspective, you're doing it because your spouse is not working. You wanted to get the work permit soon, and you've been with the company for too long, and you want to make sure that you apply under the EB3 category and get your stuff in order. And now you're looking at, you haven't been to India for a long time. So probably because you got a H1 done here and you didn't want to take the risk of traveling, and you can discuss that with your employer. Then in that instance, and if your date is current, that's what I would look at. Make sure that your date is current. And if that date is current, then I would actually request my employer to work on it. Now, then what happens is that if the date is current, then if you concurrently apply for your I-140 and your 485, then you can also get your work permit in 5 or 6 months. You can also get the advance parole. Now, through that advance parole, you can travel outside the country and come back. And of course, needless to say, after 6 months, under AC 21, section 106 of AC 21 of the Act, you can leave this employer and you can go to another employer wherein you work in the same or in a similar capacity. So those are the good things. Now, what can happen when hundreds of people do this? Then that particular EB3 category is again going to get backlogged. And at least this is good for those people who are kind of very much anxious to get the work permits, to get the advance parole, and who are eventually looking at basically going for, for changing the employers or so. If you're lucky, and if you're in the first batch of people, then the good news is that you may get your green card sooner. So that is the good side of it. And for employers, it's very important for you to make a rational decision, because all your lawyers are going to call you and tell you, hey, sir, why don't we do this? I'm sorry to say that there are some lawyers who are just out there to make money, point and blank, because if they don't have enough business, then what are they going to tell you? Is let's do this, let's do that. Employers should be careful. Employers should make sure that the best interest of the company is served, as well as the interest of the employee is served. So those factors are very important. And then only the employer needs to make a decision. You're an employer who has 150 employees. You're 200 employees. They all started coming on a desk. You need to consult with a good attorney. You can always change your attorney if you're a consulting company. A lot of companies come to us, especially when they get audited, when they get into kind of major issues, we help them. Yes, I handle the employment-based immigration section personally. So my email address is info@gehilaw.com. You can reach us. Now, people have asked me, Mr. Gehi, how's the procedure going to work? Do I need a new labor certification if I'm doing this for an employee? The answer is no. You don't need a new labor certification. In fact, you can use the same labor certification, but you'll need a new I-140 under the skilled worker category of EB3. When you file it, you need to make sure, you need to know the law very well. You need to know all the memorandums, the new field memorandum, which clearly states in 2017 that you can do a downgrade, but make sure that you call it as an amendment. That is very important. So then what happens? There are some mistakes which a lot of lawyers do because of inexperience. Not everyone is an employment-based immigration lawyer. So people go to the general practice lawyers, they go to people who don't know what they're doing. What they do, unfortunately, is they just apply for your I-140, they miss a document. It can be an absolute recipe for disaster. Now, you even need to know some technicalities that what they were going to, basically because, immigration may ask you for the blue form that was certified. Those are questions that need to be answered very carefully. And those are questions that need to be taken care of very, in a very, very systematic way. For employers, what is happening is that they're just getting blanket statements from lawyers or from consultants whom they work with. They say, okay, let's downgrade, let's do it. But the employer also has a right to know what he's doing. What is going to happen if the company gets audited? For no apparent reason. And, for nothing, just for nothing thing sometimes, it's just an aggravation. Of course, you may come out clean out of that audit. But there's a saying in English that prevention is better than cure. So be careful. We actually represent a lot of big IT companies, and we've done that in the past over the years. Email us if you're an IT company. Don't call me, email me. info@gehilaw.com comes to us directly. It's so simple, info@gehilaw.com. And then you make an informed decision. Even when you're applying for an H-1B, make sure that you look at everything from all perspectives. Make sure that you fire with all your guns. Also make sure that when you are applying for your perm labor, if you're even applying for an I-140, make sure it does not backfire upon you. So while you are moving it from an EB2 into an EB3, just make sure that the initial one, the initial petition that was filed, that has no flaws in it, and it was properly approved, because that can backfire upon you. The problem is that exactly, the whole case may be denied. And if your priority date is very close, and if you're in an EB2 category to becoming current, make sure you don't touch it. I don't recommend that. So those are some major concerns that have come up from people. Now the benefit of converting, and those are the people who are coming to us. The benefit is that you don't have to extend your H-1B once exactly you have your work permit. Then after 6 months, you can change your employer. Your spouse, if you're a beneficiary, she can get the work permit too. She can start working, or he can start working. And if you have children under the age of 21, good news for you is that they can be covered, and you can look into the Child Status Protection Act. And remember, the good news is that immigration is looking at basically when the filing date is current. So that is also helping us a lot to be reviewed in these cases. And I strongly recommend that look at this category very closely and make sure that you work with good lawyers. You have every right to change your attorney and basically handle the situation in a very important way. Now, what becomes as important as Section 204, HCFR 204.5E is very important in this case, and it should be read carefully by employers. And for heaven's sake, I strongly recommend consulting companies, go with good lawyers, folks. Because when I get cases, I've seen companies paying major fines just because some of the lawyers were not good immigration lawyers. Some of them are very good immigration lawyers, but some of them don't know the law. They just fill up the paperwork for you. And it's sad to see that some companies are happy paying $500 to a lawyer to do the H-1B. But a lawyer should know the law. A lawyer should know what is a non-immigrant visa. He should know what is 214B, 214B from the back of his head. He should know 204 from the back of his head. He should know exactly what's a 221G, what's a 212 ground of inadmissibility, what's a 212 ground of fraud from the back of his head. Those are lawyers. And even if they charge you more, you don't have to come to Gehi and Associates. Go with lawyers who can protect your company. If you are growing your IT company, if you're growing your own consulting company where you have 50 employees, 100 employees, at this stage, you've already made it big. Make sure that you go with lawyers who will work with you. Make sure with lawyers who can make your company big. Make sure that you work with lawyers who actually can protect you and who know the law if there's an audit. These are factors that good business people consider. Nickel and dime a lawyer is not going to work in your favor. Of course, you're going to find people, especially I'm talking to employers here. But at the end of the day, there's a very good saying in English that you pay for what you get. Don't get into that situation. Now, let's get back to, again, the same topic we are talking about, is now EB3 to EB2. What happens if EB2 becomes current? Your I-140, even suppose if you do not qualify under EB3, it's still valid. So that's a good thing about this. So you're not losing your EB2 I-140. But once if you convert it into an EB3, Now the thing is that exactly you got it converted, your I-140 is approved, your 485 is pending. Now what happens if that priority date does not become current? Now, if you want to go back to that EB2, you'll have to do a perm again. You'll have to do the perm again to get the I-140 approved. Then you'll have to put that priority date. So in a sense, make very rational decisions if you are an employer when you're doing this. Because it's very easy to spend your hard-earned monies. Doesn't matter if it's an employee or an employer, because at the 485 stage, the good thing is for the 485, the employee has rights to pay for his family members. But until the I-140 is concerned, you and only you as the employer is responsible. So that is very important. So yes, this is about EB2 to EB2 to EB3. This sounds like a, okay, all right. So Ritesh, if you have any other questions, you can even ask us. Now, after 6:45, we will be taking questions. So from EB2 to EB3, because we also need to please people who are interested in the topic. So now, the thing is that if you have any other questions, people can ask us. And now we are opening the floor for everyone who has any question about immigration. So Ritesh, it's your turn if you're interested. If not, good luck, and we wish you the very best. So now I have an approved EB2 from my employer based out in California. I got an internal offer to move to New York with same employer and an H-1B amendment, plus extension was filed. My job offer was for a future date, and that date kept moving. Now that date has moved to next year. Since I'm in California, can I file for EB3 downgrade and I-485 for California? Very interesting question. Now, number one, remember one thing, the purpose of the downgrade from EB2 to EB3 is for you to make sure that you're going to firstly work for the same employer. Now let's break this down into steps. You're on an EB2 right now, great. And you're saying that you want to apply for your EB3. You applied for your I-140 and your 485. But what you are promising immigration at this stage is that you're going to be working in that area of intended employment once if you get a green card. So once if you get a green card, my strongest recommendation to you is try to be in a place exactly where in your perm and your I-140 was filed. Because why do you want to take complications? It's just going to aggravate things for you. Otherwise, just stay where you are. Keep it the way things are. And then later on, after you get your green card, you can move back to the same location where you were. That's my answer to your question. So folks, if you have any more questions, we'll start taking questions on this. And we try to please everyone in terms of basically answering questions. That's the whole idea behind it. So today was a day for people who are want to move from EB2 to an EB3. Any other questions, folks, please let us know, and we'll be happy to answer. All right, so we're just going to talk about a few other important things right now at this stage. We're going to talk about people who have said that they came here on a visa waiver pilot program, and if they are out of status or undocumented, what are their options? That was a question we got. So your option, if you came in on a visa waiver pilot program, and if you overstayed that visa, you came in on a visa waiver pilot program, and if you overstayed that visa, you can still marry an American citizen and qualify for adjustment of status in the United States under the fact that, based upon the fact that you are an immediate relative of a US citizen. Yes, that is a possibility, and you can qualify for a green card in the United States if everything goes well. Now, Mike Ritke, what would be estimate EB2 date of filing in September 2021? I think we'll see some more movement because what is going to happen now from the EB2, people are going to jump to the EB3. So EB2 will move a little faster. I cannot give an exact time frame, but next time I can exactly give you some analysis what can be done. So if you're on an EB2, there's nothing much to worry about. And I think, I believe in the conservative approach. If my date is very far off, then I don't like to move too much, because you're also congesting that category. You're messing up other people who are in EB3, which is going to be nowhere. So better basically make a very rational and an informed decision as to what you're doing. Okay, so what are the risks when downgrading from EB2 to EB3? The risk is that if you had done something, if there was something incorrect in your I-140, that means that is one risk. Second thing is you need to make sure that the employer has the same, is showing a profit in the company, and he's able to pay you the prevailing wages all the time for the past 5 years. All those audits have to be done. Then you should be firing with all your guns. So therefore, it's very important for you to look at those factors very carefully. So now, what if I did not use the EAD card, which I got from EB2 to EB3? 3 goes ahead. Do I still need? Now, once if you convert, Mr. Menon, that's what I mentioned. Once if you convert, then after that exactly, at that time and if the conversion is granted to you, then after that, once if you're on EB2, you can again put the priority date back and everything, but you may need a new labor once if the conversion is done, because you're moving that to a different category. So that's my answer to your question. My priority date on EB2 is 2014. It's 2014, yes. I think a happy person, my answer is, I think, yes, you should take a chance, because 2014, it's current up to 2015. If you think, yes, I think you need to look into it, because I think you are right there. And I think, Mr. Happy Person, I think you should be pretty much okay with that, I believe. So that's something I would recommend you to look into for sure. So folks, if there's any other question, you can ask us. And remember, you can ask us any question in immigration that you'd like, and we'd be happy to answer you. So folks, this is a very important topic, because what happens sometimes you get these, and how are these shows conducted by us? We base it upon what comes out in immigration and what people want. And a lot of employment-based candidates said that, yes, we want to listen to this particular topic. And we made sure that, and also, like, anyone has any topic, you can recommend us. We'll be happy to talk about it. Now, there's something good that has happened. If you look at the October News Bulletin, EB1, that's one category I tell our brilliant viewers to consider. If you can fall under EB1A, nothing like it. And a lot of people are so highly qualified. You're an outstanding researcher, you're a professor, and you're Mr. Brilliant. You have these publications. Why wait? Look into this fantastic category of EB1A. And many people have been doing that. Look into that, and that's going to be fantastic. Another question that came in right now was about EB3. What is an EB3? You can be a skilled worker. You don't have to have a bachelor's degree if your occupation is covered. You just have to be legal in this country. Or you should, EB3 applies to skilled workers. That's what EB3 means. So even if you don't have the minimum attainment of a bachelor's degree, that should be pretty much good. So that's exactly a question. Now let's take some more questions that are coming here. I have an EB2 I-140 approved, and I have a priority date of September 2012. That looks good. My employer is fine with downgrading my application. If I downgrade an EB3 retrogresses and EB2 becomes current, yes, you will be able to file it, but again, you may need a new labor depending on your facts. So I think, that's where the problem arises. That's what I'm saying. Also, are there any other risks in downgrading? I think, I'm telling people to take the risk in such cases. If you have already I-140, and if it's a 2012, then I would recommend you that it's worth taking a risk, because even if it doesn't go through, the good news for you is that if EB2 becomes current, you still have that priority date that you can use from there. So it's worth taking the risk, Vasu. EB2 approved for location A, H1B amended for location B, but I'm still in location A. You can file, but remember, you will have to go back to that location and work eventually, because the place where the EB2 was approved, you made it very clear that you'll be working in the area of intended employment. So eventually you will have to go back to that location. That's for the anonymous attendee. What if I moved out of USA? Okay, my EB2 I-140 approved and priority date is December 2. What are the options for someone with, okay, so Maddie, the good news for you is that even if you left the United States and if your I-140 is approved, when that priority date becomes current, and if that employer is ready to work with you, it's great for you. You can come back on a green card, provided you did not accrue unlawful presence under 212A9B3. So that's something that you need to look into for sure. So thank you, Vasu, for your wonderful comments. And I need to thank everybody. If my priority date is October 2011, EB2, what would you recommend? Go for it. Go for it. I mean, because remember, even assuming, right? Assuming you went to EB3. Now, this is meant for Vasu and for everybody on the show. Even if assuming that if the date doesn't become current, you have your EAD. You can jump to another employer. If you're looking at it from an employee's perspective, you have your advance parole. Your spouse can work. Your kids may be protected under CSPA. So there are benefits of getting into the EB3. But I would not go for it if suppose of my priority date, if I just filed my EB2 petition yesterday, it's not benefiting me. You need to be in that particular category of 2011 to 2015. That's the first consideration I would make if I'm an employee. Then have an agreement with your boss. Then basically proceed from there. Then you can contact us. So folks, this was an excellent show. I need to thank each and every person and every questioner here, because I want to make a note that let me thank everyone from here. Let's start from the first person. Thank you, Ritesh, for joining us. I'm sorry we could not please you, but we have to go by what everyone requires on the show. And Rizwan Badarpura, thank you very much for your question. Dan, you've done a fantastic job. So as Amin, as always. Mike Ritka, thank you so much for your comment and thank you for the question. Mr. Menon, thank you so much again for your question. It was a great question. We enjoyed it. And Frank Zilla, thank you so much. And anonymous attendee, thank you to you for your question. Vasu, thank you for your question. And I hope we were able to help you. And Maddie, thank you again for asking your question. Again, thank you to Vasu and to everybody who has been asking questions on the show. And next week, based upon viewer demand, again, the floor is open for you to ask us any question of your choice. Even in the first part of the show, we'll be discussing important issues. And in the second part of the show, as usual, we'll be taking questions. Why? Because this show is meant for viewers like you who want to get their immigration questions answered. So we try our best to do that over here. And that's what we do. Next week, we are going to talk about very important. We are going to talk about a very, very important show. We are going to talk about the EB1A category. And that's going to be very important for us, especially why we are doing that. This is again based upon our viewers' demand. That's critically important. And again, we are going to take questions and answers for you folks. So, we'll try our best. And remember, I'm sorry if I'm unable to please everybody. I try my best. I come fully prepared on my shows. I make sure that I give you everything you want. But if I miss something, email me. I'll try my best to basically do what I can do. But there's a saying in English, you can, what do you call that? You can please some people sometime, all people sometime, but not all people all the time. And I apologize, but I try my best to please as many people as possible. So now, my father has a PhD and is published in journals. Excellent. He resides outside the US. Can he apply for EB1 from outside US when he usually visits in Texas? He can apply from outside the United States, or when he visits, he can still apply from here. He can do that for sure. That's not an issue at all. He can apply. And if he has these great qualifications, look at the EB1 category. This is what I'm saying. You may have a relative abroad who's brilliant. He can come in on a green card. Believe it or not. He's an outstanding professor. He's a well-known personality. He's a celebrity. He's Shah Rukh Khan. He's a famous actor. Look at EB1, folks. A category which is not understood by everybody. It's known as the EB1. And you do not even need a sponsor. You can self-sponsor yourself for a green card. And thank you, folks, for watching this program. Share this program, and we'll be back again next week on Green Card with Gehi. Share the show, and next week, EB1 category in detail for our viewers. and it's going to be good for corporations too. And your question and answers on Green Card with Gehi. The Ensign program is an attorney attachment, and we handle immigration cases from all over the United States and the world. We'll be back again next Wednesday, 6:30 p.m. Same place, same time. Keep watching Green Card with Gehi. And if you have any further questions, 718-263-5999, or send us an email at info@gehilaw.com. Thank you.